This is the seventh video in the Ethics and Legal Considerations for Animal Chiropractic class. In this video, I'm going to talk a little bit about malpractice. We'll talk about damages for malpractice in the following video. So one thing to keep in mind is that there is a difference in your risk when you're working with animals and your risk when you're working on humans. Now, of course, that's not going to make any difference to the veterinarians who work only with animals. But to the chiropractors who work with animals and sometimes also work with humans, you need to understand that the risks are a little bit different, um, and you need to take appropriate steps to minimize that risk. A few trends in malpractice with veterinary malpractice. One trend is that the equine practice has greatest exposure. When you're working with animals that are more valuable, whether it's equine or working with large animals in herds, um, the risk of economic loss when you make a mistake is greater, which means the risk for being sued for malpractice is greater. The second consideration to think about is that for many of these species, the cost for legal fees nearly equals the cost for the claims paid. The claims for malpractice involving animals tend to be relatively small. They're limited generally to the market value of the animal. So as a result, you may wind up spending a lot more on legal fees. So when you're thinking about whether to carry malpractice insurance, one consideration is who's going to pay for the attorney if a claim is filed. If you have malpractice insurance in place, you may be certain that your insurance company will provide that legal representation, which again may be as expensive as actually paying the claim. The third trend to keep in mind is claims for human injuries. When you're working with animals, again, especially with larger animals, there is a risk that the humans who are assisting you, either the owners or other assistants who are employed by you, may be injured by the conduct of the animals. And you need to be aware of that risk and take appropriate steps to minimize that risk. So, quick overview from a lawyer's perspective on malpractice. A traditional malpractice claim is based on negligence. Negligence claims require proof of four elements: duty, breach of duty, proximate cause, damages. So the duty in a malpractice case is usually established by showing that there was a doctor-patient relationship and that the doctor owed a duty to the client and to the animal to provide care that wasn't careless. The breach of duty means that the treatment provided was careless or that the treatment provided did not meet the standards of care for that profession. It was not the same kind of care that a reasonable, prudent veterinarian or a reasonable, prudent animal chiropractor would have provided. But even if you have a duty and a breach of duty established, you still need to prove proximate cause. In other words, that breach of duty needs to cause damages. Um, and then the fourth element, of course, is damages. The client needs to suffer damages in order to have a valid negligence claim. Now, in addition to negligence claims, you can also create contract claims. And the reason I want to point out a little bit about contract claims is these are much easier for your to be proven. So you want to avoid creating contract claims wherever possible. So a contract claim requires, again, proof of four elements. The first element is that a valid contract existed. Secondly, that the client or that the person suing performed or tendered performance. Thirdly, that the doctor breached the contract. And lastly, that the client was damaged as a result of the breach. So negligence is a duty to act as a reasonably prudent person. So if you're being sued for negligently causing a car wreck, the question is, were you driving as a reasonably prudent person would drive? If you're being sued for professional malpractice, veterinary malpractice, the question is, did you act as a reasonable, prudent veterinarian? Or did you act as a reasonable, prudent chiropractic or animal veterinarian? Um, the jury is going to listen to expert witnesses and have a chance to decide whether the professional acted negligently or not. Um, the duty is established by a doctor-patient-client relationship. And now the doctor-patient client relationship can be created by express acceptance, and that's typically what happens is there is a some form of contract that's been signed acknowledging that the doctor is taking care of the patient and that there's a connection that the client's going to pay for the care. Now, it may also be created by exercise of independent professional judgment. So if you are in the habit of providing what I'll describe as free advice, that can create a doctor-patient-client relationship. Be careful about what advice is given when you receive phone calls. It's easy to start making recommendations or to jump to conclusions or to make assumptions. The danger is that if you were wrong, it is very difficult to establish that you provided an appropriate examination over a telephone call or that you provided any of the other appropriate care that would have been provided. Danger also exists in social situations. I know every time I get introduced as a lawyer, usually the next question is, what do I do about this traffic ticket? Or what do I do about collecting this money? Or what do I do about this contract I signed? And I have to be careful in those situations that I don't give advice that would create a professional relationship. Same thing in working with animals. As soon as you're introduced as an animal chiropractor or as a veterinarian, people are going to ask you questions about their animals and about their care of their animals. Social media is another risk area where sometimes we provide or advice or make statements that we probably should not be making and could create a client relationship, a patient client relationship when you didn't intend to. You also need to pay attention to what your staff is doing because if your staff conducts themselves in such a way that they create a patient client relationship, that's a relationship that exists with the doctor. And the doctor may not even be aware of the relationship in those situations. So you need to supervise your staff to be sure that they're not creating these doctor patient client relationships. But typically, again, that's a fairly straightforward element to prove because you have express acceptance by the client and by the doctor to the relationship. Negligence, again, is a breach of duty. Proving the standard of care is usually going to require expert witnesses. Expert witnesses can be very expensive. And because they're very expensive, it limits your risk of malpractice when you're working on animals that don't have very much of a market value. You also need to be aware that the standard of care can change. Especially in a profession like animal chiropractic that is young and developing, the standard of care is likely to change. The standard of care is also affected by the statutes, the regulations for the care. And the standard of care for a specialist is different than a standard of care for a general practitioner. So there might be one standard of care for a veterinarian. There might be a different standard of care for a chiropractic veterinarian. An example of a negligence claim would be a failure to diagnose. Typically, that's going to be based on something like performing an inadequate examination or not following up on symptoms that you should have been following up with. Another situation in animals is failing to restrain the animal. You need to make sure the animal is not able to injure the owner and that the animal is not able or likely to injure your staff or your employees. Be cautious about using owner restraint. Sometimes the owner is not physically large enough to keep the animal under control. Um, Sometimes the animal is not cooperating with the owner. And in those situations, it may be more appropriate for the veterinarian or the animal chiropractor to bring in an assistant or an employee to help keep the animal under control or to take the place of the owner and get the owner in a place where they cannot be injured. Certainly, if a client requests assistance, you want to provide that assistance and not rely upon just the owner's restraint of the animal. If the client is exhibiting any kind of fear or inexperience or inability or incompetence in the restraint of animals, you need to ask them to step aside so that somebody else can take care of that. Again, if the stature of the client is small relative to the animal, the client may not be able to reliably keep the animal under control. And you also think about the procedure or the treatment that you're providing to the animal. If it's something that's likely to cause pain to the patient or discomfort to the patient, then you want to be especially conscious about how the animal is restrained so that nobody gets injured. Um, those injuries to people can become very expensive malpractice claims. So we've got the first duty, or the first element of negligence is duty. The second element is breach of that duty, and the third element is proximate cause. Now, proximate cause means that there needs to be a connection, a causal relationship between the breach of duty, the negligence act, and the damages that are suffered. And there also needs to be an element of foreseeability. The damages or the negligent act, it needs to be foreseeable that the negligent act would be likely to cause the damages that actually occurred. Um, in other words, the direction that the connection needs to be fairly direct. You can't say that the negligence caused A, which caused B, which caused C, which caused D, which caused E, which is where the damages occurred. That's not going to be foreseeable in most cases, and that's not going to be enough to support a proof of approximate cause. Now, again, with proximate cause, you're usually going to need expert proof. And when you have to pay expert witnesses, it becomes much more expensive to pursue these lawsuits, which is going to prevent many of these lawsuits from being brought in the first place. Now, this is one of the reasons you want to be careful about creating breach of contract claims. Expert witnesses may not be required for a breach of contract claim. Remember, for a breach of contract claim, I don't have to prove negligence. I only have to prove that you didn't do what you promised to do. And that causation may be much more direct and simple that does not require proof from an expert witness. And because of that, you make it much less expensive for the plaintiff, the injured owner, or the owner with the injured animal, to pursue the claim. And you don't want to do that unless you want to attract these kinds of claims. So the last element of a malpractice claim is for damages. Now, I'm going to save that and talk about that in the next video because that requires a little bit more involved discussion.